all sorts of tea on what's going on inside Washington, D.C., what regulators and lawmakers are thinking and working on, and potential risk areas for your institutions, as well as areas of opportunity. I'm Ann Petros, your host and Vice President of Regulatory Affairs at NAFCU. And today I am joined by John Coleman, who is a partner at the law firm of Buckley, LLP. John represents financial institutions, corporations, and individuals in supervisory and enforcement matters initiated by government regulators and counsels entities on compliance with consumer protection laws. Prior to joining the firm, John served as Deputy General Counsel at the CFPB and was involved in every significant litigation matter before his departure from the Bureau. So John is very knowledgeable on all things CFPB, and the latest topic, which will be the focus of our discussion today, is the decision from the Fifth Circuit Court of Appeals on the CFPB's funding mechanism, and that funding mechanism is unconstitutional. So John, thank you for joining me on today's episode.
Yeah, thank you very much for having me.
Excellent. Well, let's dive into the questions. And first, could you just walk us through the Fifth Circuit decision and what you found most interesting about that decision, or areas where you think the court's opinion maybe raised more questions than it resolved?
It's a leading question, Anne. But let me start by just trying to put this decision into a bit of context. As you mentioned, I was the CFPB, from its inception effectively, and the Bureau had been the subject of a lot of different constitutional challenges, and many of them have been resolved, including the for-cause removal provision, the recess appointment early on. This particular constitutional challenge actually has been raised since the early days. I think the first case that I can recall raising it was filed in 2013.
Oh, wow.
And the Bureau has been successful in defending the funding structure in the lower courts. I think got a decision on this from the D.C. Circuit en banc that was favorable as well. But it has not been decided by other circuits other than the D.C. Circuit until the Fifth Circuit. And I think close observers sort of saw the storm clouds on the horizon back in May when 7 judges of the Fifth Circuit issued a concurrence in another case called CFPB versus All American Check Cashing, where in an opinion authored by Judge Jones, they took the position that the funding structure of the Bureau was unconstitutional. Now, a majority of the full court in that case, it was a decision en banc. Mm-hmm. So among all 16 judges of the Fifth Circuit, a majority found that the issue was not properly presented. And so, that was not the ruling of the entire Fifth Circuit, but it was clear with 7 judges that it was a matter of time really before the Bureau would pull 2 of those judges on a panel. And litigants are not going to be so unwise as to not raise this issue. So that's sort of the context. This particular case was actually filed in 2018. In November of 2017, just before he left to run for governor of Ohio, Director Rich Cordray issued the payday rule. Acting Director Mulvaney then took over the Bureau and decided to initiate a process to revisit the underwriting provisions of that rule, which the audience may be familiar with.
Right.
That case was stayed for a couple of years while that rule writing process went forward. Director Kraniger was confirmed to take over. She completed the rulemaking process, and in July of 2020, just after the decision in the sale of law, the agency repealed the underwriting provisions of the 2017 payday rule, but left the payments provisions intact. And indeed, she ratified those, as someone who is removable at will by the president. So the case proceeded, and it has, there were multiple challenges to the payments provisions. There were challenges that they were outside of the agency's statutory authority, challenges that the agency's rulemaking authority, exceeds the Congress's authority to delegate authority down to an agency under the non-delegation doctrine, that they were arbitrary and capricious. There was a challenge based on the fact that Director Cordray was removable only for cause at the time they were promulgated, and this funding challenge. And the district court eventually ruled for the Bureau on all grounds, which was a significant win for the agency. And this was, I think, a little over a year ago. The CFSA, the plaintiff in this rulemaking challenge, appealed, and they sought a stay of the ruling, which they received from the Fifth Circuit. The matter was briefed, and the Fifth Circuit issued its ruling a couple weeks ago. And what is interesting is that the Bureau almost had a clean sweep in an opinion that in every other respect is extremely favorable to the agency. It's a panel of judges appointed by Donald Trump, conservative in their outlook, but they ruled for the agency on, its statutory authority to enact the payments provisions, on the non-delegation argument, on the removal provision argument, on the arbitrary and capricious argument. Arguments that I think certainly CFSA thought were, strong arguments.
Yeah, often you see like an APA challenge, and that failed here. Right?
And it was a very, sort of scholarly opinion, and again, very favorable to the Bureau, even to the degree that in a footnote, the court suggested that the agency's unfairness rulemaking authority is even broader than the FTC's.
Well, that's not good news.
Well, it's going to be interesting, and we'll talk about, what the ultimate impact of this decision might be. But then they got to the funding question, and it was a complete reversal. And in a unanimous decision, the panel decided that the CFPB's funding provision is unconstitutional because, in effect, Congress has, and they didn't exactly put it in these terms, but in effect, Congress has permitted the agency to encroach on its exclusive appropriations authority. And there were several aspects of the agency that they thought combined together sort of caused the constitutional problem. One was the fact that the Bureau got its money from the Federal Reserve Board, which is itself not appropriated on an annual basis. Right. Two was just the authority that the agency wields, which the panel viewed as, significant. And three was a provision that prevents the appropriations committees from reviewing the agency's spending. And combined together, the Fifth Circuit basically said all of these things together both render the agency's funding structure unconstitutional and differentiate it from the other federal agencies that are not funded annually under the sort of annual appropriations
including
process.
The NCUA.
Including the NCUA, right. I mean, the Bureau has, in defending these cases, I think reasonably enough said, look, why are we different from the NCUA, the OCC, right, the FDIC, and the Fed, who are all funded in whole or in part outside of the annual appropriations process? And that was persuasive to, the D.C. Circuit, but not to the Fifth Circuit. They attempted to distinguish the Bureau on that ground. So that was the merits holding. And as a remedy, the Fifth Circuit decided that because the rule was promulgated using funds that were unconstitutionally appropriated, the plaintiffs in this case were injured by that constitutional violation and were entitled to basically vacatur of the rule. So the rule, if the panel's decision goes into force, will be a nullity. So the implications of that, of course, are pretty immense because everything that the Bureau does is pursuant to the same funding authority. Right. And so literally every rule the Bureau has issued and every enforcement action and really every action that it takes at all could be challenged, assuming, plaintiffs have standing and there's jurisdiction, et cetera, on this ground. And so while the actual legal effect of this decision is limited to the payments provisions, which have never gone into effect, the logic of it is pretty extreme.
Sure. And so, I mean, the payday rulemaking has been sort of put off, and that compliance date pushed out further and further. What was it originally? Sometime in 2019.
August. I think it might have been August 2018, August 2019, maybe. Yeah.
Yeah.
It was pushed off, consensually, as the Bureau revisited the underwriting provisions, and then it's just been pushed off repeatedly by the courts. As part of this litigation. And, one very concrete effect of this is that the payments provisions will not go into effect anytime soon, because even if this decision gets reversed and it comes back down, then the court's going to have to decide, okay, well, when are these things going to go into effect? And the approach the courts have historically taken is, well, we'll give the amount of compliance time that the Bureau originally gave from promulgation of the final rule from our final decision resolving these things, which is, a significant amount of time. Right. So we could see the payments provisions, if they ever come into effect, coming into effect years from now, which we can talk about. But.
Right. And, what are some other, recent cases or current lawsuits that are related to this case? You mentioned other lawsuits in the past have brought, this argument forth about the funding provision constitutionality, but other challenges to the CFPB's constitutionality more broadly. You also mentioned Celia Law. I'm sure the audience is very familiar with that decision on the single director structure. The director being removable at will. But part of what happened there that you referenced was Director Krenner ratified the decisions of the CFPB. I mean, is something like that going to happen here, or is it not, the same situation because this is just specific to the payments provision of the payday rule?
Well, let's see. Let me see if I can.
That was a lot of questions.
Yeah. Let me attack it this way. Okay. I think that this is not the last word on the Bureau's funding. The issue is pending in two other circuit courts right now. Both the Second Circuit and the Ninth Circuit have the issue squarely before them. It was argued in the Second Circuit in January, so you can anticipate a decision pretty soon there, I would think, unless they decide to wait. And the Ninth Circuit, I think, also has it teed up. So we could get more circuit courts weighing in. And I also expect the CFPB will seek review of this decision, almost certainly. And the question that folks have been debating is whether the agency will go en banc, so to the full Fifth Circuit, or go straight to the Supreme Court. They can choose to go either way. And I would say the conventional wisdom is that the Bureau will not go en banc because there are 16 judges. They need 9 to vote in favor of hearing the case en banc, let alone deciding it. And they know that 7 think that they are unconstitutionally
so that's an uphill battle.
Appropriate. So it's an uphill battle, and it's unlikely that they're going to get a different decision, right? They would have to persuade all 9 judges who haven't weighed in on the issue that the agency is constitutionally funded. And just looking at the composition of the court seems like a real uphill battle. And if you go that route and lose, you've basically squandered a couple years living under this cloud. So, my view, and I think a lot of folks I talk to agree with this, is that they will go straight to the Supreme Court, and that they will try to do so soon, with the hopes that they could actually get the decision from the Supreme Court on this by the end of this term, which would be sort of June 2023. So assuming that is the case, the question then becomes, what is the ultimate outcome for the agency? Well, I think there are 2 questions. What do institutions do in the interim? and then what is a potential outcome.
I know I've already had some questions about, is the CFPB done? Is it going to be abolished? I mean, what is Congress going to do in the interim while this is playing out? And some have asked, do we have to comply with rules?
Right. To quote or to paraphrase some president who did ultimately die, rumors of my death are greatly exaggerated, right? The agency seems to have a way to weather these separation of powers challenges. And I expect that it will do so here as well. In terms of sort of the immediate impact, while the potential implications of the Fifth Circuit's decision are quite extreme, I think the immediate impacts are actually quite limited. The payday rule, which has never gone into effect, may or may not sort of be invalidated, but that decision would presumably be reviewed. There will be, cases in the Fifth Circuit that are likely going to be delayed pending resolution of this issue. In fact, the Bureau and a defendant in an enforcement action, Ace Cash Express, agreed to stay that enforcement action pending issuance of the mandate in the CFSA case. And I think it's likely to see a lot of defendants in enforcement matters raise this issue. And I think a lot of district court judges who are busy are likely to wait to see how it gets ultimately resolved by the Supreme Court before they weigh in on it. So unfortunately for the Bureau, and we saw this with the removal provision litigation, some of its cases might sort of get put on ice for a year or, from its perspective, hopefully only 7 or 8 months, but it could be a while. In terms of the rules that everyone relies upon to structure their day-to-day compliance activities, again, only the payday rule has been challenged. It has never gone into effect, so that actually won't affect anyone's day-to-day activity. And the other rules have not been challenged, have not been found invalid. In theory, a challenge could arise in the Fifth Circuit. We haven't seen that yet. And again, I think it likely that any trial court judge who, was presiding over such a challenge would just sit on it to see how this issue is ultimately resolved by the Supreme Court. And in the meantime, most of these statutes, TILA, RESPA, have provisions that say that you cannot be liable for good faith reliance on a rule promulgated by the Bureau, even if it's later declared invalid. And so my advice, has been just sort of do the day-to-day things
keep doing what you're doing.
Yeah, keep doing what you're doing. And I don't think, we have to go through the exercise at this point of trying to figure out a counterfactual world in which the Bureau never existed and, what people have to do. And I actually suspect that we'll never have to go through that exercise because, and this we're sort of getting to what could be the ultimate resolution of this by the Supreme Court.
Yes.
So here's a point of view. And I think this is an appropriate time for me to make clear that I, represented the agency when it was litigating this issue back before I left the Bureau. And so, I have a view on the merits, but, my view is absolutely irrelevant. What matters, I think everyone agrees, is what does Chief Justice Roberts, Judge Kavanaugh, and Judge Barrett, who, I think people presume are sort of the swing votes on this, what are they likely to think about this issue in the Supreme Court? And, one thing I would say about the Fifth Circuit's decision is it wasn't very satisfactory to my mind in its attempt to distinguish other agencies.
Right.
And I think the Supreme Court understands that it's the last word. And if it issued the exact same decision, not only would the Bureau effectively become a zombie agency that can't do anything.
Huge ripple effects.
Enormous ripple effects. Market chaos, real economic problems, it would also, I think, reasonably enough call into question the constitutionality of a bunch of other agencies' funding structures. And I just don't think they're going to do that. They have demonstrated time and again a very pragmatic and practical approach to these separation of powers issues. And I think, to the frustration of some, they tend to move incrementally, and they tend to develop remedies that, are in effect prospective only. And I think SELA is a good example of that. What they found there was that the removal provision is severable from the rest of the statute, so it never had any force or effect, even if it was assumed that it did.
Is that possible here?
It's so right. It is a lot more difficult here.
Right.
And I think you could imagine, right, well, they can't just say the entire funding structure is unconstitutional and therefore severed, because then the agency has no funding structure. And the court can't create one. It can't say now the agency's on annual appropriations, because
That would be legislating from the bench.
right, that would actually be an appropriations clause problem. And so, look, I thought that the part of the Fifth Circuit's decision that there is a provision in the statute that says the agency's funding and spending can't be reviewed by the appropriations committees, they thought that was part of the problem. If the Supreme Court agreed and said, well, if you get rid of that provision, it would then be constitutional, you could see an opinion that would just sever that. It doesn't really make a lot of sense to me, in part because the agency is very much subject to congressional oversight in its spending. But that's a possibility. I think, in my view, the likeliest outcome is that the Supreme Court reverses the Fifth Circuit and holds the agency is constitutional. But again, that is mostly because I have not yet seen a persuasive ground for finding that the Bureau is unconstitutional, or the Bureau's funding is unconstitutional, but other agencies aren't. And there isn't, and this distinguishes this case from SELA, there isn't some historical precedent or prior precedent, as there was in SELA, that establishes a principle that agencies must be funded on annual appropriations. In fact, it's quite the opposite. As the CFPB has pointed out, Congress has long funded, agencies through other means, including, they pointed out in a brief filed subsequent to this decision, the Postal Service has been funded through, selling stamps, and the Navy for a time paid its employees based on, bounty, basically. So it's going to be very challenging for the Supreme Court to come up with a decision, even if they're inclined at some level to clip the Bureau's wings, to come up with a decision that is both intellectually satisfying and which would, accord with its prior practice of, narrow, pragmatic approaches that are not disruptive in general. That said, okay, again, I may be biased, and I think it's also, I think a lot of people think that the Supreme Court will figure out a way. And if they can't sever any provision and let the agency sort of go along in a slightly modified form, the most likely outcome is for them to sort of say that this is a problem, but to stay the effectiveness of their decision until Congress fixes it.
Congress.
Yeah. And that there's some precedent for that. In the 70s, they found the FEC, the Federal Election Commission, unconstitutional in various respects, and just stayed the mandate of their decision until Congress fixed it. They did that with the bankruptcy courts in the early 80s. I think we're all a little skeptical that Congress will just sort of, quickly swoop in to fix the problem. And
especially with the midterm elections,
oh, yeah.
I mean, there's not a lot of incentive to resolve this issue quickly, in a way that would allow the CFPB to continue to operate,
Right.
especially if Republicans do take control of the House.
Right. And a decision, right, that punted this to Congress would affect the leverage in a very, the negotiating leverage between the different political parties in a very significant way. Mm-hmm. And I think Republicans would likely demand other changes to the agency, if as part of an agreement to mm-hmm. bring it within annual appropriations.
Right. NAFCU, for example, has supported a bipartisan commission for the leadership structure at the Bureau versus a single director. And and there are a lot of benefits to that. I mean, you're more insulated from the political headwinds, and you've got different perspectives right. coming together to make decisions about rulemakings. And you see that sort of structure in other agencies right. that are similarly funded. The banking agencies, including the NCUA. So right. I'm curious if you have any thoughts as to whether that in particular would come up.
I think it is the most obvious other structural change that mm-hmm. That comes to mind. The position of the Republican leadership on that issue seems to have maybe shifted over time. And to be honest, I don't recall what Representative McHenry's view is on whether the agency should become a bipartisan commission or not. He's presumed to be the chair of the Financial Services Committee if the House flips.
I mean, there are obviously benefits to being able to just remove the director.
Right.
Once,
right.
Your
it's
party
like,
is
we want a commission until my guy's
exactly.
the president. But I think there's other mm-hmm. things. I mean, there could be, runs at the agency's authority, what have you. If this issue got tossed to Congress, it is obviously it could at any time revisit the agency structure, its funding, its authorities. I just think that the impact of a Supreme Court decision is that it changes the dynamics in terms of negotiating power in such a way that, the Democrats who traditionally not wanted to agree to any changes to the agency, may be more willing to in order to help it escape this latest, existential threat. So, that's possible. I think it would be, it would be a time of some hand-wringing both within the agency and likely within the markets as well. But I think one thing I feel pretty confident in is that either the court or Congress is going to, in effect, ratify the agency's past actions. Okay. And we've seen that in prior similar cases where the court actually said, like, everything that the agency did is accorded de facto validity. Mm-hmm. And I really don't think that either the court or Congress is going to penalize or allow anyone to be penalized for complying with the rules that the Bureau has put into place in its 12-year history.
Sure. I mean, in a lot of ways that would be completely nonsensical. Right?
Yeah, and then completely unfair and
yeah.
Right. So yeah, I mean, I do feel pretty confident about that. So to sort of summarize, I think from the agency's perspective, there's going to be some delays. Mm-hmm. For example, we expect the agency to issue its rule implementing Section 1071 of the Dodd-Frank Act, so the small business lending data collection rule.
Correct. We're moving forward with Section 1033 on the access to consumer data.
Right. I mean, they're a little bit further away from a final rule in 1033.
Just convening the SBREFA panel and
So,
put out the outline.
So 1071, if they issued it in, I don't know, let's say the early winter, I suspect that someone will sue them in the Fifth Circuit immediately and put it on ice. Mm-hmm. Maybe not, but that would not surprise me. 1033, they can keep working on it. Mm-hmm. And the Bureau's hope would be that by the time they issue a final rule, presumably sometime in 2024, this issue has been resolved.
Mm-hmm. So can you clarify for our viewers and listeners, is it only final rules and actions, like maybe guidance, that can be challenged, right? And not ongoing rulemakings like in the proposal stage?
Right. I mean, the rule is only final agency action can be challenged under the Administrative Procedures Act. That may not prevent someone filing a challenge seeking to enjoin the Bureau from spending any money. There would be arguments that the Bureau would make to contest that. And again, my suspicion is any judge who is presiding over that case is likely going to wait to see
Put it on hold.
how the Supreme Court resolves the issue.
Right.
And even if, some judge enjoined the Bureau from doing anything, right, the Bureau would almost certainly appeal that decision, seek a stay of the decision from the Court of Appeal, So, I think that they will mostly be able to continue to do their job day in and day out. There could be some delays, particularly in enforcement and in the effectiveness of rules, but they will be able to continue to work. And we have seen post this decision, they have been not shy about putting out guidance and moving forward with their policy agenda. I mean, the 1033 Sabrifa outline came out subsequent to this decision.
Yep.
And they seem to be full steam ahead on that. They issued guidance, with respect to overdraft as well, subsequent to this.
A lot of our members are concerned about this rumored guidance related to Regulation E and fraud. So we're still waiting on if and when, that'll come to pass.
Yeah. I mean, it's been an interesting issue to watch because I recall, I think in July, there was an issue, rumor circulating that it was imminent.
Yes.
And of course, they've been under tremendous pressure from Senator Warren and others to issue guidance. Look, my view on that, and I think this is probably consistent, and I'm not sure, but tell me, with NAFCUS, is that they would need an amendment to the EFTA, really.
That is absolutely consistent with our perspective.
Yeah. And I, don't know, but I suspect that there are plenty of people in the agency who understand that. And so it's just not clear to me, first of all, even if they wanted to go through a rulemaking process to amend Regulation E, whether that would hold up. And I don't know, short of that, could they issue guidance that would actually change anything?
It's very creative interpretation of unauthorized fraud and what the EFTA says.
And I'll tell you, I mean, my sort of lay friends or spouse or whoever who I talk to about this issue, the idea, right, that they can transfer money to someone willingly and then be like, oh, I was tricked into doing that, I want to get paid back. Even there, like, that seems crazy to me.
Friendly fraud, right?
Right. No, I know. I mean, and I just, look, this is a little bit separated from the main topic, but I think the agency underestimates, some of the reactions to some of its regulatory work. And this is a great product. People like it. It's very convenient. We use it all the time in our family, and I think many families do. And, I worry that if the Bureau is too heavy-handed here, people will just stop offering it, or it'll become immensely expensive, which, doesn't help the people that the Bureau presumes states that it wants to help. So,
well, we could have a whole podcast episode on
that's
that
a different
topic
podcast.
Alone, but there's certainly a lot of concern from the credit union industry about that. But I guess we'll wait and see what happens. And I think that leads to another question about whether this decision has potentially emboldened the CFPB to continue to move forward as quickly as possible, or is kind of forcing them to pump the brakes and rethink some of their actions?
So as a general matter, I suspect it is stay the course. I actually wonder whether they could move much faster than they were moving, or be more aggressive than they were already being. I mean, my view of Director Chopra has been that he is quite willing to be, very aggressive. I don't think he's concerned overly with losing issues in court. I think he wants to move markets in the I guess now it's, a little over 2 years that he is guaranteed to be in this role. So I don't see them slowing down at all. They may be more strategic in certain enforcement matters, right? I mean, I think there's going to be an interest in avoiding the Fifth Circuit if possible. But overall, I would actually expect that there is not going to be a significant change in sort of their policy objectives and how they seek to accomplish those policy objectives. And what will be interesting is whether things get held up because of this issue, right? And are sort of, if Director Chopra is not in his seat in January of 2025, whether the new director would seek to reverse some of this. And we've seen this historically with the Bureau, as we discussed at the outset, with the payday rule. So, it's actually not great for the industry, and it's even not great for the people who work at the agency to be swinging back and forth wildly. Sure. And maybe a commission would solve that, but I think those are some of the things I'm thinking about. Is like, how is this going to impact the final effectiveness of rules in a way that may actually ultimately, have real consequences for companies.
Mm-hmm. Yeah, I mean, there's definitely some frustration, but like we said, it cuts both ways. There's benefit to having the single director structure politically, but there's also this sense of greater stability when you have a commission structure. And some of NAFCU's members have expressed frustration about the huge swings in policy direction and the focus on supervisory matters. So
reasonably enough. I mean, one thing that is interesting, and I think about this a lot, is that the OCC has effectively been run, at least at a policy level, by a single person.
That's true.
Since 1863 or whatever it was. And I don't recall hearing a complaint of the wild swings in the OCC's, policy positions between Republican and Democratic administrations. So I think the structure contributes to these swings, but I also think it is just the case that the Bureau is a highly politicized agency. It has been since,
its inception.
And the folks who either, on both political parties have extreme views about it. And I think, it is at least conceivable that some very moderate, person would run the agency in a way that would be sort of unsatisfying to, both wings of the political parties, but probably would be, pretty welcome from the industry's perspective. That doesn't seem to have come to pass. I mean, I think a lot of folks would say that Kathy Kraniger was fairly moderate in her outlook.
Right.
But we'll see whether that comes to pass someday, and whether the agency sort of settles down into a more, into a less dramatic, approach to its work.
And now following the midterm elections, if Ranking Member McHenry takes the helm of the House Financial Services Committee, you think he'll definitely put Director Chopra in the hot seat and increase oversight of the Bureau?
Oh, 100%. And I mean, that was one of my responsibilities at the agency as well, was responding to congressional oversight. And it was, honestly, night and day, depending on whether the chair of the Financial Services Committee was of the same or different political party. And, interestingly, the Bureau announced, I think in the early summer, that they were creating a new office within the legal division just to handle oversight. And I think going to be staffed largely with, term appointees who will serve for 2 years and maybe more, but at least that much. So they clearly are anticipating an increase in oversight. In terms of putting Director Chopra in the hot seat, I have to say, I think he does pretty well in these congressional hearings.
He is very capable of answering what he wants to answer and not getting into anything too touchy. I mean, he's skilled.
Yeah, he's very skilled, and I think from his perspective, it's just another opportunity to exercise the bully pulpit. And so, I don't know whether putting Chopra, in a hearing is a super effective way to change the Bureau's policy direction. I just think he's skilled. He clearly has the support of the president, as we saw, I think, last week.
Yes.
And so, I don't know if that's going to work. I think we'll see, document demands, attempts to stir up issues with the way that
have any, practical consequences or implications for the
depends
Bureau?
what they find, right? I mean, the goal always is to try and score political wins.
Dig up some dirt.
Yeah, right. It traditionally, in my view, is probably not all that effective, particularly because the sad reality is anything that McHenry says, 50% of the country is going to immediately discount, and 50% of the country is already persuaded, or whatever it is, percentage-wise. So, it is highly disruptive, I will say, to the agency, and it does tend to draw the time and attention of the senior leadership. But whether that really has an impact, I think in some senses it's posturing to try and influence the policy debate and the political debate going forward, right?
That's right.
So, and I'm a proponent of congressional oversight. I think they ought to know what's going on in the agencies they've created, but I don't think it's going to significantly change what the agency does over the next 2 years.
Yeah, I mean, oversight is, a critical function of the checks and balances of our government system. So definitely a helpful exercise. Now, to sort of close things out, what is, the time frame that we're looking at here for an appeal, either en banc or a review, request of the Supreme Court?
So we are going to learn in the next couple of weeks, I think, what the Bureau is going to do. If it seeks en banc review before the full Fifth Circuit, I think it has until early December to do so. Again, I suspect that it won't go that route. It may file a petition for certiorari early. Its deadline for doing so, I think, is in mid-January. But I wouldn't be surprised to see it do so early, again, in an attempt to get this case, to get the petition granted and to get this case calendared for this term such that it can be decided in June. The CFPB does not represent itself in the Supreme Court. It is dependent upon the Solicitor General's office at DOJ. And I think the Solicitor General's office, quite appropriately, is going to be very thoughtful about how it litigates this case, and is going to consider the equities of not just the Bureau, but of, all the other agencies who could be impacted by this decision. So that might, that takes a little bit of time. But I do, my view is if I were at the Bureau, I would be pushing to get this matter before the Supreme Court this term and try and get it resolved by June. If they miss that window, it effectively pushes a year out. And so then you're in June in 2024, and we were talking about the possibility that the funding issue gets pushed to Congress. Well, I mean, pushing it to Congress in June of 2024 means effectively it's now into 2025.
That would be chaotic.
Yeah. So again, I mean, yet another reason why, from the Bureau's perspective, I think it would be wise to seek to get this issue before the court. And everyone presumes that the court will grant. I mean, the court grants in, like less than 1% of cases, but this seems important enough. And there's arguably a split already. So, the presumption is that they will do so. And if they don't do so, in this case, they'll have other opportunities in subsequent cases. So, I guess my best guess is June of 2023. Second best guess is June of 2024. And, I could be wrong on all of those. So,
Wow. Well, it seems like we're going to be talking about this for quite some time, at least a few months.
Great.
So, all right. That does it for this episode. Thank you so much, John.
Thank you so much for having me.
Excellent discussion on this really interesting topic. And thank you to all our viewers and listeners for joining in on this really riveting topic of great importance for all the credit union industry. So if you enjoy watching or listening to the CUPP, please show your support for our podcast by hitting the notification icon so that you can get alerts for the next episode, or subscribing and hitting the like button or leaving us reviews. Tell us how we're doing. And we'd love to hear from you about potential topics for future episodes. So that does it for today. Until next time.